Hello, everyone. My name is Bruno Perez. I am one of the partners of our labor and employment department here at Verano Advogados, and I am very happy to be here with Ignacio Funes de Rioja, one of the partners and representatives of Bruno and Funes de Rioja, the Argentinian law firm of Ius Laboris. Thank you very much, Ignacio, for being here with me today. I understand that the topic we're going to discuss is hiring independent contractors. So I would like to kick off by asking you uh, if there is any news in Argentina about that topic, and when is it possible to hire someone as an independent contractor?
Hello, Bruno, and thank you very much for having us with you today. And great question, because yes, we have news. Argentina has just changed government. Now, the new president is called Javier Milei. He's libertarian, and he's introducing major modifications in the Argentinian legislation and regulations. And for this particular matter, Milei was able to pass a law in the Congress which changed the presumption of the existence of an employment relationship. This is very important because, regardless of our law, prior judicial decisions based on that presumption have decided many times that the independent contractors almost did not exist anymore in Argentina. Now, with this new law, judicial decisions will probably no longer rely on that presumption in order to to decide on misclassification of employees. And in case of claim, the workers will need to really prove that they were employees and that all the notes of the employment relationship existed in the particular case. We not only that we don't no longer have this presumption in the law, but also there were very expensive fines that Argentinian regulations included in cases of misclassification that were also abrogated by this new law passed by the Congress. This means that if you make, for instance, you make a mistake and you decided that someone was an independent contractor and he or she is found not to be one, to be an employee, well, you'll have to pay differences in vacations, you'll have to probably pay severance, notice, subsistence payment, but not those very expensive fines that we had in the law in favor of employee that by the end of the day implied multiplying the severance per 3 or even per 4. So these are major changes for us. What about you? How is it going in Brazil?
Okay. Well, in Brazil, things have not changed much in recent years. So we have a concept of statutory employment, which means pretty much that if you meet some conditions established by law, your relationship will be considered an employment relationship. But what we are seeing recently in Brazil is that our Supreme Court is really trying to enforce the concept that not every relationship that is not an employment one is necessarily the result of fraud. So the Supreme Court is recognizing more and more other arrangements made by the parties, even if they are not employment agreements. So it's trying to recognize more the autonomy of the parties in negotiating the terms of their agreements. But by law, our law is still the same, which means that every time that someone renders personal services in a continuous manner to someone and is subordinated to this person or to this company, generally the labor courts will understand that this is an employment relationship, regardless of whether you gave another name to it or whether you executed another contract, such as an independent contractorship. So I would say that in any case that a company wants to engage someone as an independent contractor, this company must be aware that it cannot act as this person's employer. Otherwise, if a labor court is called upon to decide on this matter, the court will decide that there was an employment relationship and will order the company to pay some benefits and rights that the person did not receive.
Great. And what would be the consequence in case of misclassification? Okay, we've committed a mistake, and this worker should have been an employee. What would be the consequences? You're on certain benefits you mentioned and so on, but are there fines, social security?
Yes. Well, there is a fine, but it's not that high. So I would say that mainly the consequences will be dependent of certain benefits that an independent contractor does not have and an employee has, such as paid vacations plus one third, 13th salary, contributions to the FGTS, which is an unemployment fund. So the payment of these rights that can really elevate the amount that the person was paid throughout the contract. And also the social security contributions, which are also very high for the company. So in the case that a labor court recognizes that there was an employment relationship, the company will also have to pay these contributions to the social security. And in some cases, if the company, for example, engages a lot of people as independent contractors and they really act as employees, maybe because of a labor lawsuit or class action brought by the labor authorities office, maybe the company may even be ordered to pay moral damages, collective moral damages, if a labor court understands that the company is really trying to manipulate the law and harming a lot of people or a collectivity of people. But I understand that in Argentina there used to be heavy fines for this misclassification, right?
Yes, exactly. Those fines do not exist anymore. And this is a very relevant change in the Argentinian legislation because it does not only affect the cases of misclassification, but also affect the cases of misregistration. What do I mean here? In Argentina, and as many other countries, probably executives get company cars, housing, schooling, sometimes airline tickets, and so on. Some of those, in some companies, are even stock options, and some companies are considered benefits, in others are considered salary. This misclassification also triggered these very expensive fines in the benefit of the employees that implied multiplying the severance by 3 or even by 4. These do not exist anymore, and this is also a major change because these fines indeed incentivize executives, make the rich richer, executives getting more and more, and de-incentivize the companies of giving benefits to those executives. So now, okay, if in case you had some part of the salary not properly registered according to a judicial decision, okay, you might include that part of the salary in the calculation of severance, of 13th month's payment, vacation bonus, and so on, but not trigger all those very heavy overcosts in the severance.
Okay. Well, I think it's pretty clear. Thank you very much, Ignacio, for joining me here today. I hope this is very elucidative to everyone.
Thank you so much, and hope to see you in Buenos Aires soon.